Hi everyone, welcome back. Today we're going to talk about intellectual property. So I wanted to start with a joke. Today I invented a new word, and that is plagiarism. Okay, clearly I didn't invent that. Plagiarism, not a crime, since we just worked our way out of a criminal law unit, but it is dishonest and a violation of the academic codes at all institutions, and not appropriate in the workplace either. But plagiarism, not a crime. But many times when people plagiarize, they are committing a crime, and that is violation of copyright. The only times you wouldn't be is if the thing that you plagiarized, the thing you copied, was not protected by copyright, either because copyright was never asserted or because copyright had expired and it's in the public domain. So, talk more about some of that. That's just our starting point. So, property versus intellectual property. We've talked about property in this class early on, and we talked about sort of the two divisions in common law: real property and chattels, right? So real property was land and the things on it, right? The development that happened on it. So there's a picture of the Fisher campus, right? That's all real property. Intellectual property, that's in your head. Right? Intellectual property are ideas that are in your head, and they're like the formula for drugs. Right? That's one example. It's also when you come up with a new poem, right, or a new song. That is what we call intellectual property. It's not a physical thing that you can touch and hold on to, but it is something that, in many cases, is possible to protect, like real property. So, in the Blackboard folder for IP, I did above this list a video from Marginal Revolution University with Alex Tabarrok, and I hope you've watched that already. That provides a pretty good overview that includes patents, at least, in there, which is one of the common forms of intellectual property protection. So make sure you take a look at that. They do a good job of explaining, some of the thoughts about, say, drug formulations and other things. But that's intellectual property because that formula, let's say for hydroxychloroquine, right? That's in the news a lot right now because it's an existing drug. It may be helpful in treating coronavirus or COVID-19. But the formula for that particular drug, that's intellectual property. So, I'm going to talk a little bit about tensions in intellectual property protection. So, I've got my handy-dandy map of Washington, D.C. here. Well, and there's a good chunk of Virginia, and a tiny bit of Maryland shows in that top right corner and then in the bottom right of the map. But what I wanted to start with is this pin up here on the top, right? That's on the mall, right? See the long green line underneath it? The Lincoln Memorial's down here, the U.S. Capitol's up here, that puts the White House about there, and the Jefferson Memorial over there. Right? So if you're on Constitution Avenue, that's the yellow street that goes up and down this way. Let's get rid of that line. This pin right here is approximately at the FTC, the Federal Trade Commission. So this is the picture, there's a picture of the statue that's outside. This is, I think, represents me holding back a big horse or something like that. It represents man restraining the market so that it doesn't hurt people. Right? So the goal of the FTC is to protect consumers, and one of the things that it does is to protect consumers from the harms of monopoly. So up here at the FTC and actually the Department of Justice Antitrust Division, the DOJ Antitrust Division, they also enforce antitrust laws. But they're trying to protect us from the harms of monopoly. Down here in Alexandria, so if you went across this bridge, took 395, and then I think Route 1 down here, and Alexandria, past Delray. My wife used to live there before we met. We met up here, Virginia Square. That's where we met in law school. I used to work down here. Where's right there, about up there I don't know if you saw that up there in the mall. We'll get rid of that. There we go. At any rate, it's fun thinking about when I used to be down here. Patent and Trademark Office, what they do is grant protection to inventors for that what they've done. They grant patent protection, at least if you qualify and it's not already patented. So what they do is based in Article 1, Section 8 of the Constitution. It's actually Clause 8, the Patent and Copyright Clause. That's the one that says Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So the Patent and Trademark Office is specifically about the discovery or creation of ideas. Copyright protects the expression of ideas, so that's the written word, that's music and poems and books and articles, and those are all copyrighted. Patents refer to like inventions, and so they have to actually be approved and registered with the PTO. So here's the thing, the Patent and Trademark Office, their whole job is setting up little monopolies. Now, for limited times, so they don't last forever, but they secure exclusive rights. So they're setting up monopolies. Nobody else can produce the drugs that are patented, and then approved by the FDA until the patent expires, right? There's no generic version until the patent expires. And so, but then up here at the FTC and the DOJ Antitrust Division, they're trying to protect us from the harms of monopoly. And so there's inherently some tension there but in what they're doing. So, why are we concerned about monopoly, right? Why is the FTC and to some extent the DOJ Antitrust Division so interested in protecting us from monopoly? Well, here's a little econ for you. Whoops. Let's see if we can get, there we go. Do better with that. Let's work with it. There we go. So if you have your classic supply and demand graph, we're going to think specifically about the demand, if that's downward sloping. And then if the marginal cost of producing something is constant, it may be increasing. Often the marginal cost is increasing. We'll keep it simple here and assume a constant marginal cost. Then ultimately, the competitive outcome would be here. And so we'll call this Q1 and P1, and that goods would be produced all the way out to here where the marginal benefit of the last good, that's what shows up on the demand curve, is just equal to the marginal cost of producing it. So demand curve, this is based on the marginal benefit of the good to the, I'm not sure why I put the parentheses around there. Let's go back and do that again. So the marginal benefit of the good is here, is equal to the marginal cost. That gives us the output level. So this is the competitive output level and the competitive price, right? It'll be produced and sold at its marginal cost. Now, the concern is that what if there is only one producer? What if there is monopoly power? And the concern is that a monopolist will restrict output and raise the price, so that a monopolist will have market power and they'll pick a higher price. So we'll call this the monopoly price. And then they'll choose to sell a smaller quantity. So we'll call this quantity under monopoly. And that consumers will be worse off because there will be less available and it'll be sold at a higher price. And you can even see on the graph, right, change the color here again, what happens. At the competitive outcome, where there's more of it available and it's sold at a lower price, more people can benefit, right? People will buy it all the way down to here. And so for those of you who remember or are familiar with the econ, then everything above this line and up to here represents consumer surplus. So if this doesn't ring a bell with you, don't worry about it. If you haven't taken micro, don't stress over this. But this whole triangle up here represents consumer surplus, right? That's gain to the consumer from purchasing the product because they value it up here somewhere on the demand curve, right? That's the benefit of it to them, and they only have to pay this P1 or the competitive price, right? The price under competition. But I don't know if I like green. Let's do purple. If the monopolist has market power and they're able to raise the price and sell a smaller quantity, then consumer surplus is limited to this area up here. Right? This is where consumers benefit. And then this whole area down here, this is monopoly profit, right? This is money that the monopolist can capture, and this becomes gains to the monopolist. And then this area over here, let's pick a different color. Here, this is an ugly color. This area over here, this represents potential gains to consumers if they could buy it at this low price, but they don't buy these because the price they have to pay, the monopoly price, is up here, and the value to them is less than that. So this whole area in here, all of these potential gains to consumer, they're never realized. And that is what we call the deadweight loss. And that's the DWR, the deadweight loss of monopoly. So in a very quick nutshell, this is why in general we're concerned about monopoly. Now there are some counter arguments to this too. There's questions about how much monopoly there is, what are the sources of monopoly, how long can that be sustained, how soon does competition cut into it. But these are in a nutshell, this is the simplified version of why the FTC and the DOJ Antitrust Division are trying to protect us from monopoly. So that's essentially the graph they're thinking about up here at the FTC. Meanwhile, down here, their job is creating little monopolies. Right? They're setting up. They're saying if you produce the formula for this drug, and nobody, for a period of about 21 years, nobody else is allowed to produce and sell that drug, and that means you can sell it at a higher price, and at a higher price, fewer people may be able to afford it. That's why when the patent does expire and the generic version of the drug comes out, what happens to the price? Well, it drops. People will choose the generic because it's cheaper, and even the name brand, right, will be cheaper as well. So that's, in a nutshell, our concerns about monopoly. So there are. Well, I guess that's the tension, right? And this is something that Tabarrok covers really well in the video, so this will be a review as well. But the tension in IP is IP creates monopolies, but monopolies may not be good for consumers. Right, so we might not want the monopolies, but IP by its nature creates those monopolies. And so what we would like to see, let's say with drugs or with other things, we would like to see widespread availability at low cost. Right, the marginal cost of producing additional drugs might be very, very low. Right? So we would like to see them produce a lot. So let's say a big quantity. Let me get rid of that. I don't know this time. We'll just say produce lots at low cost, right? So close to the marginal cost of production. This creates monopolies, so they're going to have a higher price and less availability. But this, and this is the important part, creates an incentive to develop in the first place. And this is where there's there's disagreement about intellectual property. Some people say we don't need intellectual property law, right? That there's a big advantage to being the first mover, and that should be enough. Other people say no, but creating a drug, for every drug that makes it to the market and makes huge amounts of money for the pharmaceutical company, there's a whole bunch of drugs that get scrapped along the way because they're not effective, or they have nasty side effects, or there's other problems with them. Just the FDA approval process can take many years and lots of expense for testing. So some people would say without that incentive, without that reward, right, the monopoly profit for a period of time, that there won't be incentive to do the research and development and come up with those drugs in the first place. And so it's not a matter of comparing. This is the argument, at least some people would give for patents. It's not a matter of comparing widespread availability at low cost over here on the right, but maybe it's not comparing that to narrow availability at high costs, right? Monopoly prices and less output, but maybe it's comparing the period of time with less output and higher prices to it not being available at all. That without the sort of the reward of the monopoly profit, people might not invest in the cost to create it in the first place. That's the argument. Some people are swayed by that. Other people are swayed, a little bit. Some people resist that. But you should be familiar with that argument. Again, Tabarrok covers that in the video as well. There are also other ways to achieve it. That's part of what the Tabarrok video talks about. What if you use rewards or prizes, to incentivize it, and then to incentivize people to try it, and then then allow it to be produced at very low cost by not protecting it in the same way. So that's something else to think about. That's the main tension in intellectual property law. So, types of IP protection. These are the ones that are discussed in the article, so I don't want to go down that road too far. But you've got patents, copyrights, and trademarks. Patents, you have to actually apply for them at the Patent and Trademark Office. There are, attorneys who specialize in this and helping people apply for patents. You don't have to have one, but a lot of people use them, right? Use a patent attorney to help them. I remember in law school, that was actually a very lucrative field. If you had expertise in a technical subject and you went to law school to become a patent attorney, that could be very valuable because the patent attorneys have to at least understand some of the science, at least enough to adequately represent it. So I think in my law school class there was somebody with a PhD in chemistry who was then going to law school, who I was planning to be a patent attorney. Probably now does very well helping pharmaceuticals or other companies navigate the PTO. Copyrights, right? These are just, you don't have to apply for them, you just assert them. And that the copyright protection lasts much longer. Trademark, right? That's for commercial marks, so probably this, if I can draw it close enough, well, that's not a very good one, but that would be patented, just like shoes. My son draws a lot of shoes, so that's a terrible shoe, but if it's got 3 stripes on like that on the side, the Adidas, right? That's probably patented as well. So, I'm sorry, trademarked. As well. Those are the main types of IP protection. You can see those and the differences between them in that article. So let me break here so that the video doesn't get too long, and then I'll pick up with a second video to wrap